This video is for educational purposes only and does not constitute legal advice. Immigration law is complex, and individual circumstances vary. Before making any decisions about your visa application, please seek advice from a qualified immigration specialist. Akbar Immigration Law Chambers can provide tailored advice for your specific situation. The UK Home Office just made a significant change to how visa refusals are structured, and if you're applying for any UK visa, you need to understand what's changed. Part 9 of the immigration rules, the section that dealt with grounds for refusal, has been completely replaced by something called Part Suitability. Now, the structure of refusal grounds hasn't fundamentally changed. Part 9 already had mandatory, discretionary, and circumstantial grounds for refusal. But what has changed is how these grounds are applied across different visa routes, how much discretion the Home Office now has, and critically, how much harder it's become to overcome suitability issues when you're applying for settlement. If you're applying for a family visa, work visa, or settlement, this affects you. Stay with us, because we're breaking down exactly what changed and why it matters for your application. What was Part 9? For years, Part 9 of the immigration rules set out the grounds on which the Home Office could refuse your visa application. It included mandatory grounds, where they had to refuse you, discretionary grounds, where they could refuse you, and circumstantial grounds that applied in specific situations. The system worked, and most immigration practitioners understood how to navigate it. But on 11 November 2025, the Home Office deleted Part 9 entirely and replaced it with Part Suitability. The structure is similar. There are still mandatory, discretionary, and circumstantial refusal grounds. But the way these grounds are now applied across different visa categories has changed significantly. And that's where the problems start. What's different about Part Suitability? Here's what's actually changed with Part Suitability. First, the refusal grounds are now scattered throughout Part Suitability rather than being consolidated in one place like they were in Part 9. This makes it harder to get a complete picture of all the grounds that might affect your application. Second, different visa routes now reference different combinations of suitability grounds. For example, a partner visa applicant might face refusal under SUI 2.1, SUI 2.3, SUI 4.1, and SUI 5.1, but a skilled worker applicant faces a different set of grounds. Under Part 9, the grounds were more uniform across routes. Third, and this is critical, the Home Office now has more discretion in how they apply certain suitability grounds. The language has shifted in ways that give decision-makers more room to interpret circumstances and make judgment calls. That means less predictability for you. Fourth, overstayer exceptions, which were relatively clear under Part 9, are now scattered throughout Part Suitability with different rules for different visa routes. If you've overstayed in the past, it's now harder to understand whether that overstaying will be disregarded or not. And fifth, this is the big one. If you have any suitability issue and you're applying for settlement, you now face a much higher bar to overcome it. Let me explain what that means. Settlement is now significantly hard under the new Part Suitability rules. If you have certain suitability issues during your qualifying period for settlement, you'll be refused settlement. Unless you can prove you've completed a continuous qualifying period of 10 years with permission and you've completed 5 years of continuous residence after the date the suitability ground came to the Home Office's attention. Let that sink in. If you've breached your visa conditions, owe money to the NHS over £500, or owe litigation debt to the Home Office, you're looking at a 10-year penalty before you can settle. And that 10-year clock doesn't start until the Home Office becomes aware of the issue. So if you breached your visa conditions 3 years ago, but the Home Office only finds out today, your 10-year clock starts today. This is a massive hurdle that didn't exist in the same way under Part 9. Previously, you might have been able to overcome these issues with strong evidence of rehabilitation, character references, or changed circumstances. Now there's a hard 10-year rule. More discretion, less certainty. The other significant change is that Part Suitability gives the Home Office more discretion in applying certain refusal grounds. Under Part 9, the grounds were relatively black and white. You either fell into a category or you didn't. Now, with Part Suitability, there's more room for interpretation. The same suitability issue might be handled differently depending on what visa you're applying for, what stage you're at, the individual decision-maker's judgment, and the specific circumstances of your case. That's more uncertainty for applicants. It also means that if you have any suitability concerns, you need specialist advice to understand how those concerns might be interpreted under the new framework. Guessing or assuming you'll be fine is no longer an option. Who is affected? If you're applying for any of these visas, Part Suitability affects you. Family visas, partner, spouse, unmarried partner, child, parent visas. If you have any history of overstaying, previous refusals, or suitability concerns, you need to understand how Part Suitability applies to your case. Work visas, skilled worker, global talent, scale up, innovator founder. If you've changed jobs without permission, breached visa conditions, or have any compliance issues, Part Suitability determines whether you're refused. Settlement, indefinite leave to remain. If you're planning to settle in the UK, any suitability issue now carries a potential 10-year penalty. This is huge. Student visas, including child student visas. Part Suitability applies across all student routes. Visitor visas. Even visitors are now assessed under Part Suitability. Essentially, if you're applying for any UK visa, Part Suitability affects your application. What you need to do now, here's what we recommend. Step 1. Assess your suitability before you apply for any visa. Do you have any history of overstaying, previous visa refusals, criminal convictions, breach of visa conditions, debt to the NHS or Home Office? Any concerns about your circumstances? If yes to any of these, you need professional advice before you apply. Step 2. Get specialist advice. Don't guess. Don't assume you'll be fine. The new Part Suitability system is complex, and the consequences of getting it wrong are serious. If you have any suitability concerns, book a consultation with an immigration specialist who understands Part Suitability inside and out. We offer a free 10-minute consultation to assess your situation. Step 3. Document everything. If you're overcoming a suitability ground, you need evidence. Evidence of rehabilitation, character references, proof of changed circumstances, documentation of time spent in the UK. Start gathering this now, before you apply. Step 4. Plan your timeline. If you're thinking about settlement, understand the 10-year rule. If you have a suitability issue now, you might need to wait 10 years before you can settle, unless you can demonstrate exceptional circumstances. Plan accordingly. We at Akbar Immigration Law Chambers are tracking all these changes closely, and we're creating detailed guides on how Part Suitability affects each visa type. Subscribe to this channel and hit the notification bell so you don't miss the updates that could affect your visa application. We're releasing videos on how part suitability affects partner visas, settlement, and the 10-year rule, overstayer exceptions explained, and what to do if you have a suitability concern. Book your free 10-minute consultation using the link in the description. We'll assess your situation and tell you exactly where you stand under the new part suitability rules. This is too important to get wrong. Part suitability is here. It's complex and it affects your visa. Don't leave it to chance. Subscribe, get informed, get advice. We're here to help. See you in the next video.